Hello everyone, welcome back to this channel. My name is Tamim Arif and today I'll be explaining the topic of Damnum Sine Injuria. Before starting the video, I would like to request you to please subscribe to this channel of Law Minds and please leave a like if you like this video. Thank you. So let's start. Firstly, what is Damnum Sine Injuria? It is a legal maxim which is made out of three words, that is damnum, sine and injuria. Damnum word denotes to damage which can be of any type like substantial damage of money, comfort, health, etc. Then the sign means without and injuria means injury. Here injury means any kind of violation of legal right can be injury or any infringement of any legal rights can also be called as an injury. Now as a whole damnum sine injuria translates to damnum or damage without legal injury. It is a common concept in the law of tort, where if any damage is done without the infringement of any legal right, then there can be no action taken. Now, let's go to the elements of it. What are the elements of a damnum sine injuria? C. The defendant's act as well as the defendant's guilty intention, which is causing harm and which is resulting to the plaintiff's loss as well as plaintiff's legal injury is element. Now, let's come to an example of it. If a person A opens up a shop near another person B's shop and with good deals, the person A is attracting more customers compared to that of B, and because of this, it is causing harm to B's business. However, there is no violation of any legal rights of the person B, as A has no guilty intention and A is exercising his lawful rights to trade. Thus, we cannot sue A even if it is causing him monetary damage. Now, to understand the concept even more, we'll be going through few case laws. Now, let's go to the case law of Gloucester Grammar School. See, in this case law, the defendant was a teacher at plaintiff school, and due to some ongoing internal dispute, the defendant left the school and later he set up his new grammar school. And now, due to the favourness of this teacher, the defendant, several students left the plaintiff school and went to the defendant school. And due to this ongoing conflict, the plaintiff had to reduce the fees from 40 pence to 12 pence per quarter, which caused plaintiff a huge monetary loss. And that's why the plaintiff filed a suit of indemnification against defendant. But the court held that there will be no remedy provided to the plaintiff, as the damage caused by the defendant is not causing any legal injury to the plaintiff. Further, in this case, the Honorable Justice also stated that there must be a presence of a legal injury supporting the damnum to claim the remedy. Further, he also states an example with his statement where he said, quote, if I have a mill and my neighbor decides to build a mill beside me, then I cannot claim for my monetary loss as it is not causing any legal injury to me. Coming to this next case, we will be going through the case of Chasemore versus Richard. In this case, we can see that the plaintiff is a mill owner and from past 60 years, he is using the underwater steam which is fed by the rainwater. Now, the defendant has set up a new well in his own area. Now, The problem arises as the plaintiff's place was placed at a lower elevation compared to that of the defendant, which was at a higher elevation. Now, the construction of the well had blocked the water supply, as the blockage was causing the plaintiff a huge loss. Thus, he filed a plaint against the defendant. The court held that the well was dug in his own area by the defendant. Even if the plaintiff has procured comfort loss, his legal rights were not harmed. Thus, the defendant cannot be liable. Now, from both these cases, we can conclude that if someone has received damage but no legal injury or nothing that infringes his legal rights, then he cannot claim for any relief. Today we understood the concept of Damnum Sine Injuria. Please do like this video and don't forget to subscribe the channel. See you in the next video. Thank you.